Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on approval under section 151 for the issue of notice under section 148 for the assessment year 13-14 beyond 4 years, where for issue of notice under section 148 the approval of Principal Commissioner of Income Tax is required, but if the approval is given by both Joint Commissioner of Income Tax and Principal Commissioner of Income Tax, then whether in that case the assessment should be turned down only because of the reason that the permission from Joint Commissioner of Income Tax has also been taken to issue the notice under section 148. This issue has been decided by Honorable Delhi ITA C bench in the case of Pitam Singh versus Income Tax Officer, and this case is decided on 5th June 2026, and the reference of this case is ITA number 7175/Delhi/2025. The present case relates to the assessment year 13-14. The notice under section 148 was issued to the assessee after 4 years by taking the permission both from Joint Commissioner of Income Tax and Principal Commissioner of Income Tax. In many approvals, it has been seen that when the approval has been given by Principal Commissioner of Income Tax, then in those approvals, even the Joint Commissioner of Income Tax also give its approval. The assessee raised a very serious apprehension before the tribunal because some additions were being made which was confirmed by the CIT appeal also. So the assessee was raising a very technical ground with the tribunal, and the issue was that the assessee was contesting the assessment on the ground that the approval has been obtained both from Joint Commissioner of Income Tax and Principal Commissioner of Income Tax, so it is not as per the mandate of section 151, so the assessment should be quashed on this ground. For its contention, the assessee was relying on the judgment of the same honorable bench in the case of Sema Mehta versus Income Tax Officer, whose ITA number is 2405/Delhi/2024, and at the same time a judgment of Mumbai ITA, that is ACIT Circle 1 versus Bharti Life Insurance Company Limited, which is reported in 128 taxmann 23. In both those cases, it was held by the tribunal that if the joint approval is obtained by the assessing officer where the approval of other officer was not required, so in that case the approval will be termed as invalid and the assessment should be quashed on that basis alone. So when the tribunal heard the matter, the tribunal said that first of all, it is very essential that the copy of the approval should be provided to the assessee with the reasons provided, and in the present case the approval of Additional Commissioner of Income Tax is also obtained, and hence the approval become invalid in terms of section 151. The tribunal said that it is a trite law that if a thing is to be done in a particular manner, more particularly those acts conferring jurisdiction like the present one, then it has to be done in that particular manner and same cannot be compromised in any manner whatsoever. So in the present case, by following the judicial precedents in the case of Sema Mehta and Bharti Life Insurance, the tribunal quashed the assessment proceedings on the ground that in the present case the approval under section 151 is not as per the mandate of the law because the approval has been given by both Joint Commissioner of Income Tax and Principal Commissioner of Income Tax. Friends, this case is very important because the approvals, as far as the approvals are concerned, the department takes the approval very lightly, although it is repeatedly has been said by the various courts that section 148 is a very potent power in the hands of the assessing officer which should be regularized by the approvals of the higher authorities, but it has been seen that the approvals are given in a very casual manner. So this is a very important case which again gives a right to the assessee to challenge the assessment on the basis of approval. At the end of this video, once again I am repeating the name of the case. The name of the case is Pitam Singh versus Income Tax Officer, and this case is decided on 5th June 2026, and the reference of this case is ITA number 7175 Delhi 2025, and the matter has been decided by Honorable Delhi ITA C bench. Thank you, friends.